Welcome, everyone. My name is Rich Overton, and I'll be your Zoom support for today's presentation. Our senior family educator, Kimberly McCoy, will be leading today's panel. A little bit about Include NYC. For more than 3 decades, we have been helping young people with disabilities, their families, and professionals. We help New York City families make informed decisions about special education, navigate disability systems, and advocate for themselves. We offer workshops, a helpline, and resources, which we have adapted to respond to coronavirus-related issues. You can find online workshops, parent support groups, and live streams on the Include NYC website calendar. If you have individual questions and would like to speak to an educator, please call the Include NYC helpline at 212-677-4660 or in Spanish at 212-677-4668. You can also fill out a help request form on our website at www.includenyc.org. We also have a Spanish website at www.incluyenyc.org. A few housekeeping tips for today. Whether you are an Include NYC veteran or you're joining us for the first time, we're very glad that you're here and we hope that you'll participate. When you enter this room, your sound and video will be off. You can share your thoughts or technical issues in the chat box, but if you have questions for today's panelists, please use the Q&A box in your Zoom webinar controls. And enjoy tonight's presentation. And now I want to hand it off to Ms. Kimberly McCoy, Senior Family Educator at Include NYC.
Hello, everyone. My name is Kimberly McCoy, and I am a Senior Family Educator with Include NYC. In today's webinar, Special Education, Family or Community Problems, we will discuss mediation and how it can help you resolve a myriad of disagreements. We will touch upon these topics, namely special education and early intervention, family issues, including co-parenting and divorce, youth-centered conflict resolution, and parent-teen mediation, housing and small claims disputes. It is exciting how many different types of disputes mediation centers take on. All the New York City centers can help on any of these issues. But first, a brief description of mediation. Mediation is a free opportunity to resolve disputes without having to take legal action. Mediation is voluntary, is available in every borough, and only takes place if both parties agree to participate. They are facilitated by a trained, neutral individual, the mediator, who facilitates the process but does not decide what happens. That choice stays in the hands of the participants. Attorneys are not necessary. As we learn some more about mediation, as well as the various types of disputes that can be resolved, we have the benefit of hearing directly from mediation center members from each of the 5 boroughs. We will have time at the end for questions and even quite possibly throughout their discussions. So we will also share contact information. And finally, you can always feel free to reach out to our helpline at 212-677-4660 if you have any other questions or concerns regarding disabilities and the systems that surround it for people birth through 26 years of age. So today we're going to start with youth-centered conflict resolution. Adria, could you please introduce yourself?
Thank you so much, Kimberly. Good evening, everyone. My name is Gulizia. I work at NYCID, the New York Center for Interpersonal Development. NYCID is the Community Dispute Resolution Center for Staten Island. You will receive or have already received all of our information, but for your reference, we are located in the St. George neighborhood of Staten Island near the ferry terminal at 130 Stuyvesant Place. My role at NYSID is as the Assistant Director of Community Programs, working with conflicts that arise outside of court, conflicts between neighbors and friends, conflicts within families, and within schools. I'll be speaking with you about youth-centered conflict resolution. Those are conflict resolution processes in which young people are front and center. I'll be talking about 3 of them this evening: peer mediation, parent-teen mediation, and restorative youth conferencing. Peer mediation is a conflict resolution process in which students, usually middle school or high school students, serve as mediators to help their classmates resolve their problems. Peer mediation is used extensively in schools in New York, whether as a complement to standard disciplinary measures or as a robust alternative. NYSID does extensive work in training students to mediate conflicts with their classmates and supports schools in implementing peer mediation programs. It's our experience that student mediators are often more effective than adults in facilitating lasting solutions because they have a better understanding of the issues their classmates are facing, and because they often do a better job honoring the principles of mediation, like letting people come to their own solutions. We find that it's sometimes challenging for adults to let teenagers solve their own problems because the adults feel like they know better. I guess it depends on where you sit. Now that I'm an adult myself, when I was a teen, I would have agreed with them. But one of the principles of mediation is that it's voluntary, because we believe that solutions are more durable and more effective if the participants in the process own the solution and it comes from them. If you have a child at home who's in middle school or high school and who could benefit from peer mediation because of conflict going on with their peers, or who would be a good peer mediator, you should reach out to people at your child's school to ask if they have a program in place or are interested in starting one. The next type of conflict resolution that I'll be talking about is parent-teen mediation. Parent-teen mediation brings parents and their teenage or sometimes young adult children together around the mediation table to address areas of conflict and miscommunication in an open and, in my experience, often powerful way. By bringing together teens and their parents with an equal voice, we often can help disrupt their habitual ways of interacting, which are clearly not working, and instead create a space where each person can share honestly their hopes, their challenges, and their frustrations, and then explore a path forward together. As you might imagine, it can sometimes be hard to get people to the table for parent-teen mediations. Not every teenager really believes that a mediation conversation will be helpful. And honestly, not every parent is ready to cede their authority and listen to their child as an adult. But I know from firsthand experience as a mediator that when parents and their children who are in conflict come together in a mediation, powerful changes can happen as both parent and child understand themselves and each other in a deeper and more respectful way. Finally, I'll share about restorative conferencing. Restorative conferencing brings together a young person who has caused harm with those who have been impacted by the harm and circles of support for each of them. As a restorative justice practice, restorative conferencing views harms not primarily as violations of rules, but as disruptions in the relationships and bonds that link us all together. Restorative conferencing provides the opportunity to acknowledge the humanity of each person, the impact of the harm, and it offers the opportunity to repair the harm and move forward. While we primarily offer restorative conferences through a partnership with youth probation that exists in all 5 boroughs, we can set up restorative conferences for anyone, young, youth, or adult, as long as the necessary participants are willing to engage in the process. If you have any questions about peer mediation, parent-teen mediation, restorative conferencing, I'm happy to talk further. You can ask them now or reach out via email to either me or your local CDRC. As Kimberly mentioned, all of our CDRCs in the 5 boroughs can help you, and we generally would refer someone to the CDRC in their borough for services. Kimberly, I don't know if there are any questions at this time.
There are no questions at this time. Thank you, Adria. But I would just like to remind all your panelists, all of the attendees, if you do have questions, we do ask that you drop them in the Q&A box, as it will make it easier to address them, either by typing it out to you via text or also live when one of the speakers are finished with their part. So thank you so much, Adria. Now we're going to be moving on, and we're going to hear from Joanne to discuss family and community affairs. Joanne, could you please introduce yourself?
Hello, good evening, everyone. My name is Joanne Pangilinan Taylor, and I am from CMS, which is Community Mediation Services. And Community Mediation Services is your CDRC, Community Dispute Resolution Center in Queens. We are located in Jamaica Avenue in Queens at 89-64 163rd Street, Jamaica, New York. So very similar work that we do with what Adria had shared earlier, but I'm here to talk about the offerings that we do in terms of community dispute resolution services that we have for community as well as family mediation. So we have the strong belief that a strong community, a support to a strong community is an empowered community, and that the whole idea of supporting the community towards a peacemaking as a whole starts from really supporting community members and especially our families. So in our mediation program involving community mediation, we offer mediation services to resolve issues dealing with neighbors, landlords, and tenants. Any dispute that comes between them, we offer this opportunity to have a conversation, and that in the hope that there could be some clarity and understanding that all the parties gain and that they're able to resolve their dispute. So typical issues that comes up are noise issues, rent issues, pets, repairs, or security deposit. So when that conversation is offered to the community, we hope that empowering them to clarify and understand the issue and make the decision themselves also prevents the issue to escalate and go to court. And that with that, the peacemaking that happens in the community is supported. From the community, from the bigger picture of the community, we go a little bit more internally with what happens and the support that we provide with family. And when families are having struggles and issue with parents being separated, and it is a very difficult time for the family. And what we hope to provide in providing mediation services is, again, this opportunity for separating parents to be able to meet with a neutral facilitator, having this opportunity that someone can be there to listen to them and help them through as they talk about what is going to happen moving forward in a separate household. what would be the schedule for the children, how are the children going to be supported financially, and what would be the main communication between the two of them as they move forward in taking care of the children. So all these things, we recognize that the communication between the parents in this new path is going to be important as they continue to raise their children as co-parents, with having meaningful interaction with the children, and as well as a supported decision making together as a family. Another support that we have is if the parents are going through and needing to go through a divorce process where they need to legally sever or separate and the marriage, there is a very specific mediation process that deals with looking at specific issues that needs to be decided in a separation agreement in a divorce process, so that parents can both legally get divorced. So in this kind of mediation process, a neutral mediator that is trained in this kind of work will sit down with the parties and have a conversation and a discussion with helping them get to figure out what would they like to do with scheduling for the children, how the children are going to be supported financially, if there's going to be financial support that needs to be given to one parent or the other, and if there is a marital asset or property, how is this property going to be equitably distributed between the two parents and the two households. All these things are important conversation that we help and support the families in their decision making. So that is with the divorce mediation process. Another family support that we provide is what we call in the surrogates court mediation, where if there are issues that is in court, that is filed in court, that's helped in terms of parents are there is a deceased person and families are needing to have a conversation with disagreement of how to move forward with thinking about who is going to be representing the decedent's estate, and conversation that the siblings of the deceased parent needs to have in terms of moving forward and decision making with the family. That is also something that we can help out in the surrogates court mediation process. So as you can see, the mediation process involving, from a community setting to a little bit more intimate with family issues and interpersonal dispute, is very much a service that we are that we provide to the community, in the hope that there is this positive and meaningful exchange that can happen in our community. And as a CDRC, as a Community Dispute Resolution Center, we are there to serve families in our community. So Kim, if there is any question that is shared, I'm happy to answer it.
There are no questions listed, but actually I just wanted to follow up with the question and maybe you
Yes.
can provide some clarity. So it sounds like a lot of this stuff is, it also can align with actions that could be legal, like that takes place in the courts. If I were, or somebody was to go through mediation and they try to, resolve the situation between themselves, but then they decided that they did want to go to court, would this preclude them from doing that?
A very good question, Kimberly. Thank you. Yes, so it does not preclude them. So what can happen is we also get referrals from cases that are already filed in family court with custody visitation issues and child support. And what happens is actually, the referee or the judges send them to us and see if the parents can mediate this and have an agreement between the two of them. And if there's any agreement in the mediation, the parents basically go back to court, bring the mediation agreement, the magistrate or the judge reviews the mediation agreement, and if upon review, if it's approved, that mediation agreement is then converted into an order. So then it becomes a binding agreement that the parents then follow. So we work hand in hand to whether the case is already in court or if it's self-referred, that the parents are doing it even without the court and want to just have an agreement that the two of them can abide and basically tuck it under the bed. And for them, that is an agreement of good faith and goodwill, then, that is for the parents to decide. So
Thank you so much for that, Joanne.
thank you, Kimberly.
So now we're going to be moving on to resolving special education and early intervention disputes. So Carol, if you could please step up.
Thanks, Kim. I'm Carol Himes, and I am Senior Manager of Family Programs at New York Peace Institute. New York Peace Institute is the mediation center responsible for people that live in Brooklyn and in Manhattan. We have offices in downtown Brooklyn and downtown Manhattan as well, but currently our services are almost exclusively being provided by either video conferencing or teleconferencing. So what we do is we do as all the mediation centers do. We provide mediation services, we provide conflict coaching, restorative justice services, and we also do have some trainings, some of which are fee-based. And you can look on our website. I know that Kim was going to post that in the chat and see more about our services. Today, I'm going to speak about two of our mediation programs that are very near and dear to my heart: early intervention and special education mediations. Both deal with children who parents or the service providers have questions about whether the child has a disability and whether services should be provided. First, early intervention. Most of you probably know that early intervention services are for children under the age of 3, and they are for children who have either health-related or disability-related developmental disabilities. And there's a question or there is a need for services to support them. Mediations in early intervention can center on 2 topics: either whether the child indeed qualifies for services, number 1, or whether their plan is appropriate for them if they do qualify. Mediations can be provided in both instances. And so the question then is, who is at that mediation? Who goes? First of all, the parent is almost always the decider for his or her child, so a parent would be there. And there would be someone at the mediation from the New York City Department of Health, which administers the early intervention program here in New York City. And it would be someone who is at a senior enough level that they have the authority to make a decision. Those are the 2 baseline have to be people there, because you can have a wonderful conversation, but if you don't have people that can make decisions, it's useless. So they have to be there. And then sometimes there are others there as well. Sometimes the service coordinator can be at the mediation. Sometimes a service provider like a speech therapist or an occupational therapist can opine, think about what's going on for the child. And then what happens is this: the mediator is in the mediation and in a neutral way, not deciding, supports the conversation, between the parent as the decision maker, the early intervention person as representing the New York City Department of Health Early Intervention, and guides the conversation where the parent and the Department of Health talks about what's of concern, what they're seeing, and then guides the conversation around what are some possible options, helps them assess those options, and then if they want to reach a conclusion and how to support the child in a different way, they would then reach that conclusion. The mediator does not make the decision. The decision makers, the parent and the Department of Health, decide. And the reason for that is this: mediators really believe that best decisions are made by the people that know the situation best, and that is clearly the parent who knows his or her child best, and the Department of Health that knows the services and the evaluations. And so the mediator supports that conversation. If an agreement is reached, the mediator writes an agreement then and there, and it's legally binding. It has to be implemented. No one can go back and say, I don't like number 1 and number 3, but number 2 is okay. Everything has to be done. So there is a written, legally binding decision as a result of a mediation that resolves the issue. Now, the obvious question then is, how often does that happen? And I'm happy to say that it happens a lot. It's about 80% of the time those matters are resolved. So that is early intervention for the little ones under 3 years of old. Next, I want to talk about special education. Special education supports children with educational disabilities, starting at preschool and then into school age. You probably know that under the law, there are 13 classifications of educational disability, and a student has to fall within one or more of those in order to receive a plan, which is called an IEP, an Individualized Education Plan, IEP. You've probably heard of that. So if there's a disagreement as to whether that student qualifies for an IEP, or whether the services or the program is appropriate for that IEP, then a mediation can also be conducted to help resolve those differences. So again, who would be there? Well, the parent as the educational decision maker for the child, or if there's someone else, almost always it's the parent, but sometimes there's someone else. And then there's someone from the New York City Department of Education who is senior enough to make a legally binding decision. In public schools, it's often not at the school level, it's actually at the administrative level, and it's usually someone called the AZ, the Administrator of Special Education. And for non-public schools, parochial schools, charter schools, then it would be someone from the local CSC. But we would have to find the right person and make sure that they have the decision-making capacity. And then the mediator would also include, or the others would include, other people that have an interest and knowledge about this. So sometimes parents come with an advocate. Sometimes the school will say, oh, well, the teacher might be helpful because he or she knows about this situation, or a service provider, or maybe it's the school psychologist. And often it's quite a robust conversation among a number of people. The last person, and maybe the most important, is sometimes the student. For children that are old enough, I wouldn't say for kindergarten or first grader, but certainly for a child in junior high school or certainly in high school, it's often very, very helpful to have that student's point of view. What's going on for him or her? How does this impact them? How do they feel? Why are they acting this way? Will this new plan work? Because we all know for teenagers, if we set up a great plan, but they're not going to do it, then it's useless. Now, of course, having that student's participation requires the parent to agree. So if the parent doesn't think that's the right thing, the parent can decline. But we often have students involved, and I think it's a really terrific thing because it supports them advocating for themselves. And then there's a mediation around, first of all, what the concern is, what the appropriate approach might be, whether the student should have an IEP, whether the program is appropriate for that child, and also other issues which are at least as important. Sometimes the communication is broken down between the parent and the school, and that really does not support the student at all. So we help rebuild that communication. We help rebuild the trust and understanding and support of that student in that mediation. So it's not just IEP, but it's beyond. If there's an agreement reached among the parties, then the mediator writes that up. It is also legally binding. And an IEP, if there's an IEP change, must be updated. And the law says that it must be updated promptly. Well, I don't know what promptly exactly means, but I know it means pretty fast, right? So the IEP has to be updated quite quickly. If there's an evaluation that needs to be taken place first, then that's done as well. And I should add, sometimes more than one session has to be offered. If the parties find that's productive, they can ask for that and come back to a second session, either to gather more information or to assess how things are going. Mediation really provides an opportunity to be creative and really child-centered. And again, it's the people that really know what's going on best, the parents who know their child, the child, sometimes the student, and the educators. And so they can really craft something that's really appropriate and creative and specified just for that child. So we really can get really refined agreements for a student and really support him or her going forward. And then the last question, which is of course the most important, is, sounds lovely to have a great conversation, but we're all busy. Does it work? And the answer is, it works a lot. In the mid 80%, 85% or so range, these matters are resolved, and resolved quickly within a matter of weeks. So it's really a terrific process offered by RC for Brooklyn and Manhattan, but all the CDRCs provide this service. So I think I'm going to pause there. And Kim, I'm going to see if anybody has any questions.
How, Carol, actually, you have two questions. The first one was, how long does mediation take?
A typical session is about 2 hours. It takes a while to have a conversation that's robust and rich enough to dig into the information. And that sounds like a long time, and yet spend 2 hours and really move ahead and move forward and figure out maybe a really good approach for a student really seems to me like a great investment of time. I've seen so many shifts in what's going on for students as a result of that 2+ hours. Now, I did mention, Kim, that sometimes we go on to a second session. That's unusual, but it's much more usual to conclude in one session. But sometimes if there's more going on or there's more information to be gathered, we can spend a little more time. But I'd say you allow 2.5 hours, and that really is what happens. Early intervention can be a little bit shorter just because there are often a little bit more defined issues. Can I also add this, that while we can certainly provide information about mediation, parents have a great resource. Include knows this stuff cold. And if you've got questions, legal questions, or what your rights are questions, call them. They are fabulous. They're just fabulous. So I would just say that as well.
The other question we have is, how much does mediation cost?
Oh, I should have said this. This is free. It's free. The law that provides for mediation is something called Individuals with Disabilities Education Act, IDEA. It has a portion for early intervention. It's got the other portion, which is bigger for school-age students, and it's free. And the reason it's free is the legislature said, look, we really have an interest in supporting students. Now, how do you support them best if they have a disability? Well, if there's a dispute, we want to make sure that they can try to, people that are in charge of them can try to unravel that. And so it's free. These are services that are totally free.
Thank you so much, Carol. So last but not least, we're going to be speaking with Titus about small claims and landlord-tenant mediation. Titus, could you please take it away?
Thank you very much, and good afternoon, everyone. My name is Titus Rich Jr. I'm the Director of Mediation at the Institute for Mediation and Conflict Resolution. The acronym for that is IMCR. IMCR is one of 5 community dispute resolution centers, as mentioned, called CDRCs, within the area of New York City, which provide alternative dispute resolution services to the residents of Bronx County. IMCR is located in the Bronx at 369 East 148th Street and 3rd Avenue on the lower level. Alongside special education mediation, my part in this today is to tell you a little about 2 prominent services which IMCR is currently providing. One is landlord-tenant mediation, and the other is small claims mediation. What has happened recently is that the courts have determined that these 2 types of cases, landlord-tenant mediation and small claims mediation, should be what is called presumptive. And that's a word that I had to look up for myself. Now, what does presumptive actually mean? Some time ago, Chief Judge Janet DeFiorio and Chief Administrative Judge Lawrence K. Mark announced a statewide initiative in which these types of cases, certain civil cases, would be referred or should be referred to mediation for some form or other form of alternative dispute resolution as the first step in the court proceedings. And I iterate the first step. They want people to realize that in order to get things speeded up and to alleviate court calendars, try mediation first, and therefore they kind of urge people to go into this presumptive ADR process. Now, even though mediation is basically a voluntary process, and all these processes that we're talking about, judges in small claims and landlord-tenant matters kind of urge and suggest that parties try mediation first, rather than wait for the courts to open up. And as we know now, courts are pretty much closed down, maybe closed down again, and sometimes cases may not be coming up on the calendar for either 6 months to a year. So we kind of look at the process we call mediate while you wait. And so people will have an opportunity to kind of mediate their cases while they're waiting to try to go to court and maybe get something done before they actually go back to court. At present, the Bronx Small Claims Court is functioning under this presumptive model. So since the courts are closed or have limited activities due to this COVID pandemic, these presumptive cases are referred to IMCR and other CDRCs for processing virtually. People will do this over the Zoom platform, over a telephone conference, or any other platform that they're familiar with, but it will be done remotely since there is no, or at least limited, face-to-face confrontation within the courts. And they are sent to IMCR staff and done by IMCR's volunteer mediators. We have at least 80 to 100 volunteer mediators who give their time judiciously and graciously to help the people of the Bronx to resolve matters that mean much to them. We also have interns from John Jay College of Criminal Justice, who, in order to get their bones, as it's called, to make things good for them, we have interns processing these cases as well. Now, these cases usually come to IMCR in batches of 3, 4, 5, 15, 20, whatever we can handle, whatever a CDRC can handle. We will let the landlord-tenant mediation program know that we can handle this much, or it's too much right now, whatever. So when we get them, we usually have a window of about 45 days to process and to end it up. The second prominent case type that IMCR is involved in and focusing on very heavily is the landlord-tenant mediation. Now, this is a program that was initiated by the Mayor's Office of Criminal Justice, of where CDRCs are in contract with Mayor's Office of Criminal Justice called MOCJA to provide ADR services to the people of the 5 boroughs. And also through the Human Resources Administration and New York City Housing Preservation Division, HPD. These cases usually involve situations where tenants are behind in their rent. And since the pandemic, we've got lots of these cases because of the pandemic. People have lost their jobs. They are at least downsized in work. They're not having the resources to pay their rent. And because there's been a stoppage of rent evictions, meaning that landlords just can't throw you out during the during this pandemic because you can't pay their rent. What are landlords to do? What are tenants to do? So these types of cases are being referred to the CDRCs under this landlord-tenant mediation program. So, and even if their cases are not coming through the HRA and New York City Housing Preservation, any case that has to do with this type of landlord-tenant rent arrears, they are factored somehow into this landlord-tenant mediation program. And what will happen is that IMCR will attempt to arrange mediation sessions between the landlords and the tenants to see if they can work out some arrangement for paying rent. Many tenants are still paying rent, even during the pandemic. Others may not be able to do so, but yet maybe on a limited basis. And so we try to give landlords and tenants an opportunity to work out some type of arrangements so that they can catch up on the rent arrears. And we do this through this landlord-tenant mediation program. These cases are also referred to IMCR for processing virtually through Zoom, through the telephone, any other type of platform that tenants are familiar with. Many tenants are not familiar with these platforms, as even I am sometimes. And we do this through IMCR. We set this up through IMCR staff and volunteer mediators, as I mentioned before. And if the parties can't reach an agreement or refuse mediation, then these landlord-tenant matters are put back. The court is notified that there was no resolution, there's no settlement, there's no agreement, and they're sent back to court for the court to re-enter into the calendar and give her a later date, keeping in mind and notifying the tenants and landlords that sometimes these cases may not be back on the calendar for 6 months to a year. And that's basically my contribution to this at this date and time. And thank you very much. If you have any questions, I'm still here.
Thank you so much, Titus, for that. And thank you all for participating. So now we're going to ask all of the panelists to please turn on their cameras. We do have a few more questions that, that did come up. the first one was for Carol. Carol, one of the questions was about Orton Gillingham. And basically it was, would mediation be appropriate for securing Orton Gillingham based reading curriculum if the child has been diagnosed with dyslexia?
So thanks for that question. And we certainly have talked about appropriate multisensory approaches to supporting students with dyslexia in mediations, absolutely, including Orton and Wilson and other multisensory. Absolutely, it's been the subject matter of mediation.
So I just actually want to follow up with that. I know that both parties have to agree to the mediation. Do you ever see any pushback from the schools maybe about entering into mediation with the parents?
Look, mediation is voluntary, but I will tell you the schools have been very welcoming of mediation. I think when there's a disagreement, most often parties really want to resolve it. It's not comfortable for anyone. And so if it's reached a pinnacle, then it's often helpful to have mediation. And has anyone ever declined? Absolutely. But we find that really these are often not welcomed, because you don't want to have you don't want to have discord, but when there is discord, the support is quite often welcomed.
Okay, and then another question was, Carol had mentioned that, and anyone on the panel can take this. Carol had mentioned that an actual session is normally about 2 hours, and that sometimes there could be a follow-up session. But from, say, like on average, and maybe this is too difficult to answer, from like start to beginning, how long could it take? Because I know that, say, something like an impartial hearing or a court date could take months. So how long on average would mediation take?
I mean, do you mean from the time the request is made, Kim?
Yes.
I think that largely relies, depends on the schedules of the participants, but I mean, we've definitely scheduled mediations in the same week that a parent has made the request if the stars align. I think, more typically it's usually a few weeks from the time we get the email to the time we have the mediation. I don't know for the other centers if that's also your experience.
That is, yeah.
Sorry, Joanne, you go first.
No,
Go ahead.
no, that is also similar for us. And the other thing, to the frequency of the session. So it depends. Like when I was talking about the custody visitation or parenting, mediation, a divorce session, that definitely we can expect multiple session. And depending on the number of children involved in the household, if it's just 1 or 2 children, and when we talk about divorce session, maybe like we can expect like 3 to 5 sessions, but you have multiple children and a lot more properties involved, then that could take into, an additional sessions or 2. So, but again, we give that decision on how the frequency of the session, that goes back to the parties on how more time they would like to invest, but we are there as mediators to support them and in this journey moving forward in their conflict.
Thank you. And then we have another question. Can one attempt to have a mediation and then escalate to an impartial hearing?
So let me answer that. If in special ed and early intervention, if the parties reach an agreement on a topic, then it's legally binding. And so you can't then relitigate it. But if the matter is not resolved, then certainly the parties can go to an impartial hearing as well. Similarly, if a lot of time has passed, even if there was a mediation, but then there's a new issue that comes up, the parties have a right to either go to mediation or an impartial hearing. So the short answer is, if the issue is resolved, you can't then go back to the hearing, but if it's not, you can, or if there are different issues.
Thank you for that. And I also just wanted to let people know that I am adding mediation information for the Department of Education. They now have a mediation liaison. So I am dropping that in the chat. And so if you guys have any questions, besides speaking to our boroughs, you know, Ms. Lee Himes, Titus, Adria, Julia, or Joanne, you can also reach out to the DOE liaisons there. So thank you for that. And I just want to make sure there are no other questions. I think we have answered everything. So yeah, well, thank you all so much. This has been a really great conversation. I appreciate your time and I appreciate all of your input. If you have any other questions, like I said, you can always reach out to our website, and we have also dropped the information for each mediation center in the chat. If you don't have that or you weren't able to get, you can go through it and find it. However, we also have a tip sheet that we provide at Include NYC that has everybody's information on it also. So you could always use that. And before you all go, I would just ask that you do please fill out the, we have a poll that we pulled at the end. So if you could just please answer the poll quickly, that would be great. Thank you so much, Carol Lee Himes, Joanne Paglian-Taylor, Adria Gulizia, and Titus Rich Jr. Thank you all so much.
Thank you.
Thank you. Thank you for coming.
Thank you so much.
Thanks. Bye-bye.